got the result in today. Chille got convicted on both counts. I suspected he would be. I figured he wasn't getting away from this one. These are tough charges to beat. I'm taking a look here at the docket. I'll explain it to you. It was a very short case done in one day. I expected it to take a little bit longer than that. There was only one witness, it looked like the state, and one witness, which was Chille. That I figured the cops would bring in more than just one cop to testify, but hey, you know, they got the win, so that's all that matters. Let's take a look at the docket. Here's the docket. He was convicted right here. Boom, boom, boom. There was a motion to create a standby counsel for his attorney, which is kind of an awkward thing to do. Judges don't really like it because what you're saying is I'm competent enough to know the rules of evidence. I'm going to be held to the same standards as a lawyer. There was a bench memorandum filed the same day, probably supporting the standby counsel argument. The matter was heard today and it was a one-day trial. And it says motion to exclude witnesses by the state, motion granted. So I don't know who they excluded, but here are the grounds for exclusion of a witness. Cumulative testimony. He's going to testify to the same things that the defendant is testifying to. Another one would be incompetent testimony. The person is testifying things they don't have any direct knowledge of. So Brandon Bork, I think, was the cop. And then the defense witness was Jose DeCastro himself. He testified. Then he rests. Then the motion, now this is a typical motion brought by defense attorneys. It's a motion to dismiss, claiming that the prosecution did not meet its reasonable doubt standard, which is roughly equivalent to clear and convincing evidence. Then what happens is the defense attorney will stand up, and that's probably where this came in, was not by Jose DeCastro arguing this, but a lawyer saying, hey, look, you know, these are the elements to meet it. I think the statute's vague as to this, therefore they haven't met their burden, or the prosecution's main witness said these things, and that would not meet the elements for a conviction. I've already gone over what the elements are: willfulness in some instances, others could be negligence. I mean, these are all purpose statutes, which makes them dangerous. And then defense rests, motion to dismiss, an argument in favor of said motion by the defense, argument against it. So of course the prosecutor says, no, hold on. Yeah, you can't dismiss the case on these grounds. It says, thereupon the court found the defendant guilty, arguments made by parties regarding sentencing. I could see the defense attorney saying, well, it's a first time offense. You ought to be able to let him go. That is within the court's parameters to do. Now, here's what happened. If the maximum sentence is 6 months per charge, and the judge gives him 6 months as a first offender and 6 months for another one as a first offender, and then runs them consecutively, so that's a year in jail, that would generate its own appeal. And the appellate courts might say, you know, in all the cases you've done, how did this guy get the heightened punishment? How'd you give him the maximum? So the judges always play that game back. They anticipate a appeal. And they say, well, we gave him the mid-range sentence for each one. Well, then that's not an abuse of discretion. Surprised me was the consecutive sentences. I wasn't expecting that. I warned against it because it could turn a misdemeanor into a real pain in the ass, especially if you get 90 days. I didn't think he was going to rack up this much time. This is really a harsher sentence than I expected for him. Then right here, it says judgment has been entered, remanded. Whoa. No cash or security there, no bail, you went right to jail. Do not collect your $200, do not pass go. Nope, none of that. Case closed, court order. I can't get a hand on a minute order. That would just simply say what the judge's findings were usually, and they're probably pretty brief. And then it says both of defendant's cell phones were returned to his counsel and is in his possession now. So this was possession, property that was turned over to the lawyer as his client is being carted off to jail. So there you go. Very hard to win an appeal on a misdemeanor case unless you really want to throw a lot of money at it. I was mentioning how the Nevada statutes, in my opinion, you know, looking at this from a California perspective and as a constitutional lawyer, this to me looked unconstitutional because it was too broad and too easy to subjectively bust somebody. I'm never in favor of a law like that because, like I said, an innocent person can get busted. Anyway, he's got an uphill fight because the Nevada Supreme Court has already ruled, and I showed you this, that these cases are constitutional, especially when it involves officer safety, and here you've got a cop involved. His only play then, after going through the appellate court and then hoping for a petition to the Supreme Court of Nevada, where I think all of this will get rejected because the appellate court's hands are tied, is to the Ninth Circuit in hopes to overturn Nevada. Now that will cost a fortune. And he's gonna need real appellate lawyers for this. This is not something you can do on a Home Depot project. Appellate briefs are nasty. I think I had 5 or 6 appellate briefs on anti-slaps. And they could easily be 60 to 70 pages and almost one case per line. You just can't argue the facts. It's and you got to show violations that would deprive someone of their due process. There's a lot of discretion that judges have, and typically everything is imputed into the judgment to make it rendered so that it makes sense, so that it can't be overturned. They would have to file an appeal. They would have to, obtain the record. They would have to go through the grounds for appeal and then echo these arguments at least 3 times. So that's it. Game over. I'm amazed at the sentence, stronger than I was expecting. And I think he's got some other cases pending, which won't help him either. And in fact, could result in additional sentences that are stronger. But there is one big problem. How much probation time did they give him so that if he gets out of prison or gets out of jail, any violation of those conditions is a separate offense, and on top of that could send him back for the remainder of his sentences on these 2 convictions. So this is a big deal, and you know what? Very surprising. I didn't expect this harsh of a result. I felt like it was harsh considering we went over the rules for the Justice Court, and typically they tend to have leniency on first-time offenders. Now, maybe he isn't a first-time offender. You guys have kind of mentioned some of his other stuff going on. I don't know how much of that was in front of the judge. When a judge looks at a sentencing report, she can really think of anything that is out there to wait on the sentence. So maybe there were other things in front of her that we don't know about that, made her feel like a stronger sentence was warranted. So there you go. the cop to just, put the it's the You are not the law.
You are breaking the law.